My uterus has been tingling for about 3 months.
Yeah, you can still do contact.
I don't know.
If it's not fine, like,
Okay, sorry about that. I couldn't get to my email.
I mean, you could do it
For
without.
some reason, get into my U of L email, and I had our PowerPoint in there. Did everybody have a good spring break?
no.
Okay. Usually people don't say no. Okay, who went out of the country? How about that? Yay. Okay, we've got one out of the country, out of the state. Yeah, I'll take that almost half. Who was in warm weather? Not enough. Wow.
We had a tornado. If that counts.
It was warm, but it was like 120 miles per hour.
Was the weather bad here?
We had a
We
tornado.
had some very high guard winds.
Oh, okay.
You didn't see the Norton Hospital garage collapse thing?
Is she serious?
Yeah.
Yeah.
No, I missed it all. Sorry.
Couldn't even wear wigs.
Not me.
Nothing was safe.
Couple of housekeeping things. The attendance sheet is circulating. Sorry, some people's names still aren't on it. I don't know why, but you really are in the class. Second, I forgot to tell you last week that the personal jurisdiction assessments are in 275, if you can pick them up. And then third, one pattern that I saw in those that's really bothering me, so I just want to say it again out loud, that to determine personal jurisdiction, whether a state has authority or the power to force a non-resident defendant to come and defend themselves, it's a two-step process. So first, again, it's a statutory analysis, which is, does the long-arm statute apply? Second is a constitutional analysis. So a lot of you are shaking your head, yeah, we get it, but then when I read your assessments, I'm like, a lot of people said, oh, well, the long-arm statute applies, so there's personal jurisdiction. No, you need both. So it's not a or, it's and. So you need both the long-arm statute to apply and the one of those 5 or 6 paths to personal jurisdiction, meaning one of those have to work. General jurisdiction, specific jurisdiction, in rem, quasi in rem, and so on. So it's not a or, it's and. The other thing that was bugging me is a lot of you use 1391, which is a venue statute, to say that there's personal jurisdiction. And those are two totally separate things. So remember I've said like 100 times, but I'm hoping it's now all starting to blend together. Because when I said it the first class, it doesn't really make sense. But now that we're moving through the semester, it should now starting to make sense. That to file a case in civil court, you need personal jurisdiction. So that's that two-step statutory and constitutional analysis. You need subject matter jurisdiction. Remember, it's federal question or diversity jurisdiction. You need venue. Venue, remember, just tells you where within the state of Kentucky, which state within Kentucky, which court within Kentucky you can file the case. Eastern District, Western District. So for the people that said, oh, there's personal jurisdiction under 1391, you applied the venue statute properly, but that doesn't mean personal jurisdiction. That just tells you where within that state, assuming that there is personal jurisdiction and subject matter jurisdiction, and they were served properly. Venue just tells you where within the state of Kentucky you can file the case. Any questions about that? It's really like driving me bananas. I want you to understand it because it's on the bar. And they'll test you on those 5 things. They do every year. So if you're not sure, raise your hand. They say it's an old commercial that you're probably too young to remember. Raise your hand if you're sure. No? Okay. It was a deodorant antiperspirant commercial. It's called Sure. I don't even know if they make the brand anymore, but that was their tagline. If you're confident, you can raise your hand. All right. Tough crowd. That's okay. I'm all right with that. I think that's it. So I put up the readings for the rest of the semester. So there's no question about, thank you for your email. So there's no question about what you're reading and when and what's left. The last week we're doing just review. So as you are transitioning into the last 2 weeks of classes or week, start writing your questions down, because I'm going to ask you what you have questions about, and then I'm going to make the exam review based on those questions instead of telling you stuff you already know. All right, so any problems, questions, or concerns? No. I did remember to get the 2 Starbucks gift cards for the best complaints. Here's the problem. They're really good, like half of them. People that really tried. And so I can't, it's like with a clear conscience, I'm struggling on how to pick 2 when really there's like 10 and I'm not gonna buy 10 gift cards. I bought the gift cards before I looked through them. I was like, oh crap, maybe that wasn't such a good idea. It's different when it's like an objective test, like multiple choice. You can be like, oh, well, they got 80 right, they got 82, but I'm struggling. So just know I'm gonna figure it out by tomorrow. I'm not gonna rely on who has the neatest handwriting. That's goofy. That was a joke. But seriously, I'm gonna pick 2. And what I might end up doing is because some of them are so good, there's like a cluster of 10 that are driving me nuts. Is literally just spread them out, close my eyes, and pick 2. But I will tell you who those top 10 people are, so you know who you are, and just know that you didn't win the lottery. It's not that you didn't write a phenomenal complaint. Okay. Are we ready to talk about pleadings? All right, so before we start pleadings, just a reminder, so pleadings is great because those things that I said to file a case in civil court, you need these things. Well, this is the pleading that you're going to fill out and take down to the courthouse to start your case, to file your case officially. So the complaint that I had you draft in our last class is a pleading. And so we're going to talk about some of the parts in that pleading, many of which you already know because you already drafted it. So it should come to you very easily, hopefully. So we're starting out with Chapter 6 today with a discussion of the history of pleadings. Historically, there's been a distinction between courts of law, which I'm not going to grade you on this. I care that you know about the modern law, but anyway. There's been a distinction between courts of law and courts of equity. There used to be a dual court system. And essentially American courts at some point stopped having these dual court systems and just combined them into one. And so additionally, I wanted to highlight from the readings that modern procedure rules have essentially abandoned the notion of trial by ambush. A lot of times in television, they'll sensationalize the courtroom process with those aha moments where they say, isn't it true, Mr. Johnson, that you were really at such and such house? That doesn't happen anymore because of modern pleading rules, because everyone, by the time you get to the trial stage, whatever evidence you have against the other side, you've already exchanged that with them through the discovery process, so there's no aha surprise moments, very rare. And so on the Federal Rules of Civil Procedure, as we talked about in the very first class, the whole point of them is to encourage full disclosure, transparency, because they don't want to reward clever lawyers, essentially, who can seize upon a surprise and disadvantage a client. And so, again, the idea of these rules is to make everything as transparent and open as possible. The idea is that it'll ferret out the truth, and the truth will rise to the top. And so the first Federal Rule of Civil Procedure was not created until 1938, so it's relatively new if you consider where we are in history. And so the first rule, Rule 1, which again I'm not going to test you on this, but basically the first rule provides that with the exception of a few cases, such as bankruptcy and admiralty law, that the Federal Rules of Civil Procedure apply to all civil actions in federal courts. So that's the very first rule, and it just says these rules apply to all civil actions with a few exceptions, okay? Then they created a second rule, Federal Rule of Civil Procedure, that just said there's one form of action, a civil action. And you might have heard of that movie, it's really old, I forgot the guy who stars in it, but a civil action, that's where the title came from. There's one form of action, a civil action. And that's Rule 2. So the whole point of Rule 2 was to eliminate that dual court system that they had for centuries, which again were courts of law and courts of equity. So that was the purpose of Rule 2. And so let's talk about what are pleadings, okay? So pleadings are documents, right, in which plaintiffs and defendants set forth their claims and defenses. So again, pleadings are documents in which plaintiffs and defendants set forth their claims and defenses. Examples include a complaint or an answer. So I would ask you on the exam, which of the following is a pleading? All of the following are pleadings except which one? So make sure you know what things constitute pleadings. Additionally, if you take a look at Rule 7, which I have behind me, it sets forth the types of pleadings that are allowed in federal court. I don't have the rules set out, but it tells you the types. These are basically variations of the complaint in the answer. Party complaint, answer to a counterclaim would be another example, answer to a cross claim. So they're just different variations of complaints and answers. So again, plaintiff files a complaint, right, which is the pleading in federal court. Defendant responds with an answer. No, I wasn't negligent because so-and-so happened for X, Y, and Z. So plaintiff files a complaint, defendant files the answer. If you look at Rule 10 in your free time, again, not grading you on this, it gives just general guidance for pleadings. So when you're attorneys, I want you to know that you could go there. So it basically gives you the format of that sample complaint that I handed out. Tells you where to put the case number, where to put the plaintiff's information, the defendant's information, what order, where you put venue, statement of the claim, etc. So it might be helpful to look at that, but to be honest, when you get out of the law school walls, obviously all the law firms, even the sole practitioners, have sample complaints, and you just kind of plug in the information like we did, and you move on. So it might be helpful to think of pleadings as the gatekeepers, right, to the judicial system. You have to get beyond the pleading stage to get to trial. The plaintiff has to allege a legitimate claim, essentially, or in their complaint, or else the case will be dismissed without wasting any more of the court's time. So for these reasons, oftentimes pleadings are considered to be, again, the gatekeepers to the court systems to try to weed out or ferret out frivolous lawsuits. You'll see in our readings for today and tomorrow some examples of that. So we're going to discuss some of the federal rules that apply to a plaintiff's complaint. The first one is going to be Rule 8A as in apple. Okay, so essentially 8A is important because it tells you one of the, I think, most important things you must include in a claim, right? So it tells us what the plaintiff must include in a complaint. Essentially, there are three things that 8A says must be included, which I have listed behind me. A statement of the basis of the court's jurisdiction. Remember we said in our little drafting exercise, so-and-so has jurisdiction over the defendant, Technion, whatever it's called, because there's diversity jurisdiction. Or in our example that we did in class, it was because there was federal question jurisdiction, because in our example from the last class, he was saying it was an age discrimination claim based on a federal statute, right? Second, a short plain statement of the claim showing that you're entitled to relief. And then lastly, what are you asking for in terms of damages and recovery, right? So what are you asking for in terms of damages and recovery? And even though I include these rules on PowerPoint slides, just a friendly reminder, they're all online. So you just Google Rule 8A, civil procedure, and those three things will come right up, or 7A, or Rule 10, whatever it might be. I'm just pausing, some people are handwriting all three. Takes a little bit of time. Yes?
Is your exam multiple choice only?
Yes, with the possibility of 5 short answer. That was off topic.
So now you're gonna create exam anxiety. Yes, sir.
Is there anything that's not a complaint, or sorry, is there anything other than a complaint or a response that is also a pleading? Or is it gonna be subcategories of those?
Subcategories of those two, based on the Rule 10.
Okay.
Oh, sorry, I didn't see your hand.
I'm used to it.
No, I was looking that way, go ahead.
So just to clarify what he was asking, like, filing something like a motion, that a motion's not the same thing as a pleading, it's a different category completely.
Technically, a motion is a pleading for civil procedure 1. I don't think do we cover motions? Yeah, we're not gonna cover motions, but technically, yes. So now she's gonna make me renege and tell you about Civ Pro 2. But for Civ Pro 1 purposes, it's just complaint and answer. Any document essentially that you file is gonna be called a pleading. Okay, moving forward. All right, so 8A1. This is pretty easy. Again, you just have to establish your subject matter jurisdiction either through federal question or diversity jurisdiction. 8A3, the demand for relief sought, pretty easy too. You just are asking for what you want in exchange for whatever harm you feel has been done. And then 8A2 must contain a short and plain statement of the claim showing that the pleader is entitled to relief. The standard employed in federal court is what they call notice pleading, okay? And so basically it allows the complaint to be pretty general, meaning that statement of the claim portion. The main purpose is basically just to give the defendant notice of the relevant claim so they can prepare a reasonable defense. So it can be pretty broad, and then as you go through the litigation process, discovery, you can amend your complaint, but initially you can just say McDonald's was negligent in failing to maintain McDonald's was negligent for failing to maintain a clean food environment. You know, she got food poisoning, right? That's enough. But later on, you can expand that into more. But they just need to know, oh, this is a lawsuit against, you know, they're saying that we mishandled our food, we were negligent, and therefore, this is how we need to start our defense. So again, it's just a really broad statement. So what'll happen is, sometimes people will fail to state a claim upon which relief can be granted, which is one of those motions you can have dismissed. Doesn't happen very often, but the point is, you can, I don't know if we have time to cover a case like that, I'll have to look and see, but essentially you can say, I don't really know what they're suing me for. And they failed to state a claim upon which relief can be granted, meaning they failed to adhere to 8A1. The short, I don't know what I'm supposed to defend myself from, because it's not really clear. So what happens then if a plaintiff fails to fulfill those requirements of 8A2? It's called a 12B6 motion, okay, 12B6. I don't know if I put that on the slide. I did. So it's a 12B6 motion, and essentially what you would do is basically say that the complaint is lacking actually any of those three things, and the case will usually just be dismissed without prejudice, and the judge will say you need to go and clarify this, refile the claim again. It's very rare. I don't know if I've ever heard of a case where it's dismissed with prejudice. We're not trying to screw people over. We're just trying to make sure that a complaint is filed with enough information so the defendant knows what they're defending themselves of. What if a plaintiff fails to satisfy the requirement of 8A1, meaning to include subject matter jurisdiction in the complaint? Same thing, you're going to file a Rule 12B1 motion for lack of subject matter jurisdiction. Okay, lack of subject matter jurisdiction. So basically, the plaintiff can say there's subject matter jurisdiction for the Eastern District of Kentucky to hear this case because you're going to file a Rule 12B1 motion for lack of subject matter jurisdiction. Okay, lack of subject matter jurisdiction. So basically, the plaintiff can say there's subject matter jurisdiction for the Eastern District of Kentucky to hear this case, because it's dealing with, the Age Discrimination Act. Well, as a defendant, I could say, no, if you really look at their complaint, it's a defense. Their defense is based on the Age Discrimination Act, but their actual claim is based on a state law claim. Remember the Motley case? And so really, this case should be in state court and not federal court. They really don't have subject matter jurisdiction. And so I would challenge that with filing a 12B motion. And so Rule 12 is important when you get out into the real world, because that's the rule you'll use the most, because you're trying to get the plaintiff's case dismissed, thrown out, right? So the Rule 12 have all these motions, essentially 12B 1 through 5, but they have like a motion you can file for dismissal for lack of personal jurisdiction. A motion you can file for dismissal for lack of subject matter jurisdiction. A motion you can file for lack of personal jurisdiction. So those are motions, Rule 12, that allow you to dismiss a case if you feel like the plaintiff is trying to either make you come to a state that doesn't have jurisdiction over you, make you go in a federal court when it should be in state court and whatnot. If you Google Rule 12, they'll show you some of those motions. Is that your hand up, or are you playing with your hair?
Yeah, sorry.
Okay.
So is Rule 12B6, is that a demur though? Like, is it alleging the facts are true, but they're dismissing just based on the rule?
12B6, we'll cover Rule 12 later, and so hold that. Anything else? Sorry about that. I just can't swim in that direction right now. All right, moving on. Prayer for relief. So some sample forms, again, the law firm has those things, not a big deal. I think we're ready to jump into the Haddle case. Well, Haddle 1, there's 2. Considering you all just had a week off, are you like sad that you're back? Okay. I don't feel like, hey, we just came off spring break and girls gone wild, guys gone wild. You were outlining the whole time or something. Okay, so that's sad. When I was in law school, I enjoyed every spring break. I never outlined. Now Thanksgiving break I did because I didn't know, that I shouldn't. But after then, no. So of course I'm going to try not to call on the same person. But you remember I lost my list. It's hiding, or someone took it as a joke. But let's see. So if I've already called on you, just tell me, and I won't call on you again. Have I called on you, Sydney Lane?
Yes.
Awesome. Have I called on you? I called on you. I remember that one. Tabitha Douglas. Where art thou?
Right here. No, I haven't been called on.
You look very unhappy about that.
I'm honestly not prepared.
Oh yeah, I love honesty. All right, so Tabitha Douglas. And I would call on you the one day, right?
Exactly. I've had outlines every other day.
I know, I've seen you prepared as participating. Unfortunately for you, I have to adhere to my rule. I can't discriminate based on gender. So I have to treat you like your colleague, so I'll call on you the next class.
That's perfectly fine.
And the one after, unfortunately. Sorry.
That's fine too.
I feel bad for you because you're actually usually prepared. I feel bad. Why did I call on you? Darn. If you weren't prepared, usually I wouldn't feel bad, but I actually feel bad. Well, Jacob Burdett.
Okay.
Okay.
No.
Yay, now you're done. Do you want to pick a colleague?
No.
So I've done that before where they pick someone. Like who does that? But they do it. That's why I'll see if I can catch someone. They've done it before. William Razor.
No, I haven't called.
All right, you're done. You helped your friend the last time, so I hope he's gonna help you. You were doing the ventriloquist thing. All right, so we've got Razor. And because it's spring break, I'm going to call on 3 people I'm concerned that you guys are not all going to be there today. Razor. I forgot that quick.
Purdue.
She over here make up
Burdette,
names.
and we're almost done with this ruling process. I called on you, Noah, right? Because I liked your name was Franz.
No.
Oh, but I love the name Franz. I'm surprised I didn't. So I met this lady at Georgia State who's a doctor there in the med school, and she was emailing me correspondence, and her first name was Franz. And I assumed I assumed that she was a different, now see, I'm trying to be politically correct. Now, if I say gender, then that might offend people, so I was trying to figure out the right word to say. But I thought she was gonna be different. I'm like, I don't know what the appropriate word is to say. So, and she said that she intentionally, at Georgia State, they allow you to put, Ms., Mr., other, like you can put pronouns by your name. And she leaves it off because she says she gets more opportunities because they assume because she's a male that she's more competent, and because it's the medical field's dominated, so. Anywho, I just remembered that story, so I'm surprised I didn't call on you. You look calm, are you prepared? Alright. So if I wasn't prepared, I would just go for it, because at least I skimmed, like in law school, I skimmed enough to know the facts. But I never said no, because I never wanted them to like call on me again or be a a-hole. So I would just wing it. Because who was winging it before? Was it? You did so well. You got the record for that. Yeah, he did really well. Okay, let's go then. Let's get this out of the way. So the great thing about this book is that it includes a copy of the complaint that was filed in federal court for this first cattle case, the 1996 one. And so it gives you a chance to see kind of what a complaint looks like. It also gives you a chance to see a case move from the complaint stage through the district court, then through the Court of Appeals, and then all the way up to the Supreme Court. So it's nice seeing the progression. So do either Burdette, Razor, or Franz want to just give me the facts? Franz, get it over with.
So the original complaint is that he was cattle, was wrongfully terminated because the president of the company Healthmaster fired him when they found out that he was going to testify against him, and they had charges brought against him for fraud.
Excellent. All right, so I'm just going to say it a little bit louder, but he did a great job with the facts. He wasn't long-winded, just important stuff, and we keep it moving. So we've got Michael Haddle, the plaintiff, middle management employee of the firm that did the Medicare billing. Federal authorities launched a criminal investigation. Speaking of which, and I know I'm not supposed to do this, but it's too juicy. Can you believe the cheating scam? So we got to talk about that on Tuesday when I have more time, but that is so juicy. I'm so excited. Sorry. So federal authorities launched a criminal investigation of the firm, and the plaintiff agreed to testify before a grand jury concerning the superior's actions, right? Okay, so we know according to the plaintiff, in retaliation, they're mad at them for their cooperation with the federal authorities. The major shareholders of the firm, Garrison, directed the supervisors, Malloy and Kelly, which sounds like Star Trek names, to fire the plaintiff. So the plaintiff sued Garrison in this case, Malloy and Kelly, and the firm, which was Healthmaster Corporation. So what was the basis for a federal court subject matter jurisdiction? It should be paragraph 5 of the complaint. So what was the basis for a federal subject matter jurisdiction? Was it diversity jurisdiction, federal question jurisdiction, either Burdette or Razor? That's an easy question.
Federal question.
Thank you. Based on what statute?
The Civil Rights Act?
Yeah. Say it with confidence. All right, so we know the plaintiff brought several claims, including, in addition to what he said, the Georgia, which would be state, RICO statute and fraudulent conveyance, but the lead claim and the one that was a federal question, as he stated, was under the Federal Civil Rights Act of 1871, which was later codified or changed into Section 1985 of the USC. Which basically creates a cause of action for any person that is damaged, any person or property, that's damaged. Why is my voice doing that? was not a wrongful, termination claim. Could this case have been brought as a diversity action? No, because if you look at the complaint, you can see that the plaintiff was a resident of Georgia versus the defendant Garrison, South Carolina, and then Malloy was also a resident of Georgia, so that would have destroyed complete diversity because you had a plaintiff and defendant in this case that were residents of the same state, which was Georgia. So they could not have gotten this case in the federal court by diversity jurisdiction. All right, so attorney, who's left? Is it Burdette?
Burdette.
Okay, making sure I'm learning your name late. How did the defendant challenge the sufficiency of the claim? What type of motion did they file?
Do you mean how, like, what did he challenge it under?
Yeah.
He said that they saw retaliation against him, and that's not allowed under
Excuse me. Weird.
the statute under 8A2.
Okay. Yes, and what kind of motion did they file to challenge 8A2? How it was presented?
12B6.
Perfect. All right. So they brought a 12B6 motion seeking dismissal for failure to state a claim, essentially saying the plaintiff didn't satisfy that 8A2 requirement. Why wasn't it obvious that the plaintiff had stated a claim? Why wasn't it obvious? Well, it wasn't obvious because it wasn't his employer that was behaving poorly or nasty by firing him. Meaning, wasn't it his employer that was the one that was behaving nasty? Perhaps, but the nastiness is not a federal cause of action, right? Being nasty is not a federal cause of action. One has to find a specific federal statute that creates liability for the behavior in question, and essentially the plaintiff is saying they did not do that. So what did the applicable federal statute provide, meaning the Civil Rights Act of 1871? Can someone tell me what that provided? What did that provide? Which one? So, Section 1985. What did it provide? There's 3 of you post-spring break. You've got colleagues willing to bail them out. Go ahead. I don't care.
So is that only for a plaintiff that's actually suffered an actual injury?
Yes, and what else? What is the purpose of Section 1985? What does it aim to do? What type of bad behavior is it trying to stop, Elizabeth?
To keep third parties from interfering with employees, like testifying in federal proceedings.
Yes. So the purpose of Section 1985 is just aimed at preventing conspiracies to intimidate a plaintiff from testifying at trial, and the conspiracy might injure the plaintiff's property or person. So why, according to the defendant, didn't the allegations fit the statute? Why didn't it fit the statute? Attorney Razor, why didn't it fit the statute?
There was a precedent in the 11th Circuit, Peter and Moran's case, that said an at-will employment was not constitutional protected interest, and so therefore he had no problem.
May I ask you a question? So you did that answer so easily, just right? Textbook response. Perfect. Why didn't you volunteer when I just asked if you're prepared? I don't understand. Like, nobody wants to show off when they're called on. Is that not like the look how smart I am? No. I always wanted to be like, I'm smart. You want me in your study group because I want your outlines. I don't know. All right. So in terms of why, according to the defendant, didn't the allegations fit the specific statute? Because the defendant's job under Georgia law was at will. As you know, at will employment means I can leave when I want, and you can tell me to leave when you choose to as the employer. So the subject to termination for any reason, so the plaintiff had no property right in the job and was thus not injured with the meaning of the statute by dismissal. When they say you don't have a property right in the job, as a tenured professor, I have a property right in this job. It means that I have the expectation that there will be continuous employment. If you're at-will employer, there's no expectation that you're going to continue to be employed. You hope you are, but there's not a contract in place. All right, so the defendant's basically saying that in order for the federal statute to apply, the plaintiff must suffer again some type of injury to a constitutionally protected interest, right? Remember that the federal statute only bars conspiracies to which deprive a person of property as part of a conspiracy to intimidate the plaintiff from testifying. So a plaintiff must have a property interest that's being attacked essentially by the defendant. So Attorney Franz, what was the district court's holding and reasoning?
They dismissed the case without prejudice, basically saying that he failed to state a federal claim on 2A.
Perfect. So they agreed with the defendant and granted, as he said, the motion to dismiss. They looked at precedent, as Attorney Razor was alluding to, from the 11th Circuit. Cases interpreting the Federal Act and held that the Georgia law of employment barred any claim of property under the Federal Act because the plaintiff was an employee at will. So this case also indicates that the district court declined to exercise supplemental jurisdiction over the plaintiff's state claim. Why was the dismissal of the state claim, why was dismissal of the state claims appropriate? So supplemental jurisdiction, we're going to cover in CIPRO 2, but since it's vaguely mentioned, I just want to say that essentially did we cover that already? I don't think we did. Oh, we covered? I covered, oh, you know what it is? Who can remind me what it is? 1367. Or you add yes.
It's when federal courts normally don't have jurisdiction, but they can choose to exercise it.
Right, and attach additional, say it. State claims. Yes. All right, so here, wow, did I teach that with removal?
I think so.
And you all actually remember what it is?
Barely. So is it not on the test?
Okay, so. Well, all right, so let's keep on moving. One important thing to emphasize about Rule 12b-6 is that a 12b-6 motion lacks the legal sufficiency of the plaintiff's, attacks the legal sufficiency of a plaintiff's complaint. So the court may not make a factual determination on 12b-6, okay? So they can't make a factual determination. So that is what Attorney Elizabeth
Mwanga.
Attorney Mwanga was asking about. So the court, again, can't make a factual determination, meaning whether or not it's true. All they're looking at is whether or not the complaint or the statement of the claim is clear enough that the defendant knows what they're being charged with and can adequately start to defend themselves, okay? So with a 12b-6 motion, the court must assume, they just assume that all the factual allegations are true. They're not going to debate. Assuming that you were negligent. Is that negligent in running the red light and injuring the defendant? Is that enough information in that statement to let the defendant know, oh, I need to defend myself for negligence in this car accident? And the answer is, of course, is going to be yes. So in the Haddle case, the court assumed that all of the plaintiff's factual allegations were true, and the district court found, again, that the complaint failed to state a claim upon which relief could be granted. Again, because the job was not property within the meaning of the statute they were trying to use. All right, so they're unhappy with this decision, so they're going to appeal it to the 11th Circuit, which is our next Haddle case. In terms of the Court of Appeals holding, we know they affirmed the district court's holding and held that per the holding of the Morris v. Lance case, as Attorney Razor was highlighting, the employee was at will, so no property interest is present, so they cannot use this federal statute to file the claim. So now we're all the way up to the Supreme Court. Haddle 2, or 3, technically. All right, so why did the Supreme Court why did they decide to hear this case in the first place? Why did they even decide to hear it? Yes, sir. It wasn't Razor, it was your co-counsel.
Oh, I was gonna say there's jurisdiction splits, they want to solve the issue.
Absolutely. There was a jurisdictional split between the First and Ninth Circuit. They were interpreting this differently, so they needed to resolve that split and enter the fray and say this is the law of the land. So the issue, thank you, before the Supreme Court, the question essentially is whether the plaintiff must suffer an injury to a constitutionally protected right in order for this 1871 Civil Rights Act to apply. So again, what the Supreme Court is trying to decide is whether the plaintiff has to suffer an actual injury to a constitutionally protected right in order for the Civil Rights Act of 1871 to apply. Okay, so what was the court's holding and reasoning, Attorney Burdett?
The Supreme Court said that he actually did suffer an injury because he was the victim of a conspiracy between Garrison and Kelly conspiring with the law.
Okay, let me back up. Did they reverse the 11th Circuit or uphold the 11th Circuit's decision?
They reversed.
Okay, and they held in favor of the plaintiff, right?
Yes.
Perfect. Since they disagreed with the 11th Circuit, they essentially said that you don't need to suffer a constitutionally protected injury. And I think you were saying something a little different, but I'm not sure. So basically they said nothing in the language or purpose of that statute or act establishes such a requirement when they were the Supreme Court's interpretation of the Civil Rights Act of 1871. So again, they said you don't need to suffer a constitutionally protected injury. So the fact that the employment at will is not property for purposes of due process does not mean that the loss of at-will employment may not injure the plaintiff, person, or property. If I lose my at-will employment, yeah, it's going to injure my person because I can't pay my rent. There is an injury there, and if you shouldn't have let me go if it was for discriminatory reasons, I want some back pay. I want some money, right, for the suffering that I endured for the mistreatment. So they said that the Supreme Court, in interpreting the statute, said the act really is focused on intimidation, not deprivation of property. So they looked at the legislative history of the act and said, the reason it was created is so that they wouldn't intimidate plaintiffs. We want plaintiffs to feel like they're in a safe space to pursue these types of claims, and they're not going to be essentially bullied. They said that the terms injured in his or her person or property define the harm that the victim may suffer as a result of the conspiracy to intimidate them. They also cite a 1915 case, Trox versus Ranch, where the Supreme Court states that the loss of at-will employment is an actionable injury. And so, how does the court, Attorney Frantz, respond to the defendant's complaint? How do I say this? How does the court, let me try this a different way. First of all, do you agree with the court's interpretation of that the statute is just focusing on intimidation and injury shouldn't be required?
Yes. Well, I mean, I think that some sort of injury should be required, but like they said, they changed their definition of injury. I think that's the right track.
All right, Attorney Razor, you agree with the court's stance?
Yeah, I agree.
Does anybody not agree with the stance in the class? No? All right. So why do I have you read this case? What is the purpose of reading this Haddle case and seeing it move up the course? Well, basically, it's to highlight the importance of Rule 8A, right? To remind you that you need these three things, which I have listed behind me, should be included in every pleading you file in civil court. The Haddle case basically provides us with guidance on how to address Rule 8A2. The next case, which is the Iqbal Supreme Court case, seeks to answer the question of what does 8A2 mean, meaning what do you mean by a short, plain statement showing that the plaintiff is entitled to relief. So the Iqbal case is supposed to help us better understand what qualifies as a short, plain statement. This is a really interesting case. I actually like the Iqbal case. Someone besides Attorney Frantz with the facts. Iqbal.
We didn't have to read that. We stopped at 85, 385.
No, you didn't.
Yeah.
No, if you look at the pull up Blackboard.
Yeah.
I read it.
But that's for
Yeah,
you
but
read
even
for
if
the
you
week.
read it, I can't cover it if everyone else did it. It's not fair.
Mondays 367 to 385. Tuesdays 386 to 400.
Who has it pulled up so I can see? ooh. That was easy, so you only had the one little baby cases?
Yeah.
Alright. That is interesting. Alright, well, I'll wait on Iqbal. I like Iqbal. Well, that's not fair. I should call on those people again. Kidding. My mistake. Alright, so let's take a break. And I'm gonna pull up some sample complaints that I have in my email folder. And we'll look at it and see what it looks like in the real world, and then I will let you go. So 5 minutes. That small baby reading, reading. Yeah, like how could you not today when it's so easy?
Oh yeah, no. I mean, I used to and she gives us a break.
Actually, I'm next.
Because
I know you're my dad.
5 That was my breakfast like every day. Chicken biscuits every day. Yeah, I just got
And you're done now. I wish I was in your spot.
There's no case law on someone having a vested right in a non-human interest that wasn't the actual legal
Right.
It was just a slip in the system like 20 years ago where somebody coded it in that way. So in other ordinances, there's reference to on the zoning maps are, but there's like.
What is this?
It's so everything runs with the housing development things.
They don't want residential.
Because there's neighborhood members live in adjacent property, and they don't want it. So actually road planning is going to be where's the property here, and we don't want it. And so there's also like so they're like bad things because like they should have my official like agencies. But they abstain from voting in that.
Yeah, he'd be like,
Yeah, and you're like, it was a nightmare. We put it together, but yeah, like, okay, so I think you just don't get, because you read so many different areas, and then like, yeah, I'm trying to do a lot wrong, but we'll see. That over like a huge headache. Right, so it's like that. Rushing steps back, like something that we did. Like, I just asked that was I should have looked at yeah, I was like, that's what I had. I think that's what you have to do. It was just very confusing. I kind of wish I lost my voice and brain so I just have like
You cut me out.
I don't think you should be in the picture. I was sending it to James. He already want to beat you up. He'd be like, who out there? I'd be like, Dimitri. He heated.
all my time did.
I mean, you know, like, everyone that avoided you, right? That's a win for everybody. But, yeah, I thought there was an outside chance that the thing is, this happened with the SEC too. What happens on Sunday? So, Michigan State Arena on Sunday, they're done in like 10
well, you know, obviously, number 1, 2, 3, 4, which is what
they totally ignore what happened Sunday, unless it's like wild. Like if he gets in, it wasn't. I mean, some people can still be a They did hit 15 threes on Sunday. I mean, that's their game. Yeah, I think the flag is saying all that. Yeah, they were like
yeah, so then I'm
No, it's been a while, girl. Don't do me like that.
It is what it is.
Yeah,
I'll be prepared for next time.
Okay, Jessica, you ready?
Nope.
Who else?
Who in here would have liked to see Attorney Mwanga in like kindergarten? Like she was a kid that you're like,
I did not know how to
you
sit down.
consider doing another career. You like she's really smart, but she's like the kid that asks the questions that are really good questions, but you're like, you should know that as a kid and you want to hit them, but you can't. Well, who says it? But what makes you the boss? And you're like, really? Yeah. All right. So here's some sample complaints just to kind of help. I started out with just a very traditional one, and then I found some more fun complaints, and then we'll be done. All right. So you can see the same. This is law firm, but Same thing, you got the plaintiff versus the defendant. You've got the introduction, blah, 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 kind of what's going on. That's basically, it'll be called the introduction or the facts. They typically will list the parties.
Match.com.
And Tinder, trouble in paradise. So those are the parties. We'll see what the juicy complaint is. You know that there's a complaint filed, which I was trying to find really quick that I couldn't, about Tinder that charges more based on age. So that for Tinder Plus, they charge a higher rate if you're over the age, I think, of 50. And this guy said it was age discrimination. I covered it in my employment discrimination class. He said it was age discrimination, and Tinder said no. It's just that we feel they're not going to be able to get out of it because it's not a good reason for it. But Tinder's explanation is we're trying to appeal to a certain market, and it's a marketing strategy. It's not trying to be discriminatory. Meaning, basically, we don't want people 50 and over on our site. That's not our target market.
So that's discrimination.
Yeah, it's not gonna sit well. You can Google it, but it's a really interesting lawsuit. So look, yay, jurisdiction and venue. Yay, we're actually learning stuff we need. Venue is proper in this judicial district pursuant to California Code of Civil Procedure. So this is a state law case. I apologize. Defendants reside and transact business in the county of Los Angeles and are within the jurisdiction of the court for purposes of service of process. So essentially they're saying the defendants are domiciled in Los Angeles County, and more important, based on that long-arm statute, they transact business within the state. So let's see what juicy is going on here. So Whitney Wolf has been a driving force of Tinder from the very beginning. As far back as 2012, before there was even a Tinder, Wolf was a key player on the team that produced a wildly successful mobile dating app. So basically, it sounds like she's not screwed. Along with the co-founders, Wolf has been part of, the company. While the group was initially working on a customer loyalty rewards app called Cardify, the team soon began to explore the possibility of developing an app to facilitate connections with people in the user's geographic vicinity. We already know that's what Tinder is. So Wolf saw the potential and began aggressively lobbying Mr. Rad to shift the focus of the group away from the Cardify app towards an app that would eventually become the Tinder app. So what's their complaint? What are they upset about?
Did they steal it?
I'm trying to see copyright.
Glitter box.
It's like a Facebook thing.
That Avon for penises.
Yeah, so she said she designed a flame as a logo for the new company. Sounds like copyright. But mostly what's more important is just seeing juicy for me. I wanted you to see kind of how the complaint is set up. I'm trying to get to the next section. It's kind of long, a lot of counts here. Go. There we go. First cause of action, plaintiff, Fair Housing and Employment Housing Act. Plaintiff was a member of the protected group under the statute. That's interesting. Discrimination based on sex. She thinks because she's a woman, maybe she was pushed out. So what's important is that you can just see kind of how this is set up. And for state, someone asked me a question at the break I want to emphasize. If you're following a case, this class focuses on federal rules of civil procedure, federal courts. If you're filing a case in state court has their own statutes for subject matter jurisdiction, meaning their own set of requirements. So I had mentioned to the student, like a state court would say, oh, if it's a case, with an amount under 10,000, you have jurisdiction. Small claims court has jurisdiction over you, or family court has, so the state, just know that whatever state you're in, you'll need, if you're filing in a state court, you'll need to look up what their particular statutes are. Here's another complaint here. Go back. It's a little juicy. The Hollywood Reporter, and again, same format. Hold on, actually, that's the one I want to show. Sorry. I tried to email it to myself. It didn't come out yet. So I like this one because it was the Kardashians.
Oh my God.
But it's in the Western District Court of Louisiana, so it's a federal case. And the allegations are, sorry, I don't know how to make this go away, is that the plaintiff's complaint consists of, they're asking for a temporary restraining order. facing imminent danger of bodily harm. I was at a Pizza Hut in Shreveport, and Herman Cain was there taste testing his arch rival, and I saw Herman Cain making a sex tape with Kim Kardashian in the men's bathroom at Pizza Hut. Who believes that, right?
I have multiple questions.
And Herman Cain violated campaign finance laws because Kourtney Kardashian is pregnant with his child. So we see some, but you see why you need pleadings to weed out frivolous lawsuits, because you'll waste the court's time. So again, he's talking about a scandal with a love child. Although it's juicy, you can Google it and read it later. I'm more concerned that you see how the complaint is set up, because there's a motion to dismiss that I want you to see. All right, so I'm mad I don't know how to make this go away. But authority to dismiss, you see this 12B6. So they're trying to dismiss the case for obvious reasons. Failure to state a claim upon which relief can be granted, you think. A district court may dismiss an action or its own motion under Rule 12B6 as long as the procedure that is employed is fair. This procedure is fair because the report and recommendation provides plaintiff with sufficient notice and opportunity to respond to the possible dismissal of this case. And so, just letting you see how it's formatted. Another one is a dismissal of complaint under 12B6 is appropriate if it fails to plead enough facts to state a claim upon relief that is plausible on its face. So look at that. They are citing the Ashcroft case that we're going to cover tomorrow. So you see how important this case is. So every time, typically when you file a complaint, there are certain cases that, again, are already in your form, or your, I don't know what you call it, but you have a sample pleading at the law firm. You just kind of go in your internal system. I need a pleading for civil case, federal court, it comes up. But you can see how important this is. So in Ashcroft tomorrow, we're going to talk about, they changed the law. So it used to be whether or not the claim was possible, and they changed it to, is it plausible? There's a difference between plausibility and possibility. Sure, it's possible that they're aliens, but is it likely that they saw an alien? Is it plausible? So just that little shift that the Supreme Court did in Ashcroft versus the Ashcroft case versus Iqbal made a huge impact, and we'll talk about that yesterday in terms of what types of cases now are being dismissed. It actually increased the number of cases that cannot get past the pleading stage and move throughout the court system. So it created a stronger gatekeeping mechanism with this Ashcroft case. And so, but you can see how, again, I just wanted you to see how it's worded. Rule 12B6, again, for dismissals. And then I had another one I wanted to pull up very briefly. Here they said the dismissal was warranted in this case. Look, plaintiff's allegations are either delusional or a poor attempt at entertaining himself by filing a frivolous lawsuit. Yeah, so that's the whole point of the pleadings. This is a great example of why we have pleadings. Because otherwise, without this, you would waste the court's time. Just imagine how many people would file cases against Kim Kardashian just to try to get her and a lawyer in court. Talking about really a sex tape in a Pizza Hut bathroom? He's delusional and a love child. But you see the point. So it's just a gatekeeping mechanism. And then lastly, sweet little Miley Cyrus. I wanted to ask you, this is a lawsuit, a copyright lawsuit, saying that listening to the Jamaican song, We Can't Stop, she's accused of copying that. And so saying that basically the Jamaican composer is saying she took parts of the song without permission. The suit was filed in federal court of New York. And so my question to you is, I'll just read this really quick. In the suit filed Tuesday in federal court in New York, Michael May, aka Florigan, says that he wrote the song We Run Things in the 80s, and that song was a #1 hit in Jamaica, was additionally met with a great acclaim in the UK, Canada, and so on. The song contains the phrase, we run things no run we. Things no run we, that sounds
It's Jamaican.
And so the suit also contends that the song was largely rooted in some other music he did, and so on. So if you were the attorney, junior attorney, and you've been asked to write this case, based on just those limited facts, we know a couple of things. So what state was the court filed in?
New York.
Federal court in New York, okay? So we know it's federal court. If we think about subject matter jurisdiction, why do you think it was filed in federal court? doing some application.
Diversity?
You definitely would have had a strong case for diversity jurisdiction. Do you remember the exceptions?
Federal question and patent.
Patent law, yeah. So remember, there's a group of cases, copyright, patent law, that have to be heard solely in federal court, meaning they automatically have subject matter jurisdiction. So we know that's in federal court. It's a copyright case. What do you think the claim is that the plaintiff is stating? How would you articulate that? Just spit it out. The defendant, Miley Cyrus, did what?
Stole my song.
Somebody say it?
She committed copyright infringement.
Yes, thank you. Say it louder.
She committed copyright infringement by using his song.
Again, the statement based on Rule 882 just has to be plain enough to where you know what the charge is. So the defendant, Miley Cyrus, violated copyright statute 2956, Section 4, by using music from the song We Run Things on her new song in violation of this act without authorization. And then in terms of the next thing is going to be what claim or relief you're asking for, where typically they're asking for money, right? We want X number of dollars. We want the royalties that came from this particular song, any album sales, profits from album sales or song sales, singles, you know? So that's the amount of relief you would ask. But you can see how this all works, right? Say yes.
Yes.
He's gonna have a hard time proving the case, though.
Oh, copyright cases are super hard to prove, but meaning with songs. But anyway, so that's where we are right now. So all we know is that pleadings are documents filed to start a case. We know that pleadings have to adhere to Rule 8A with that short, plain statement, relief upon which you're requesting, and then that there's jurisdiction for this court to hear that case. And then we're going to transition into the Iqbal case on tomorrow. We're going to talk about the different types of pleadings, meaning when you have a heightened pleading standard, when you have to give more than just a plain statement of the law, and why, and under what circumstances. Any questions about today's, what we covered? No. Okay, you look, yes.
Could you go over the addition of the pleading one last time?
Help me out.
Documents in which plaintiffs and defendants didn't get that far in.
Oh, no, I was just saying, I was just repeating what I said earlier, that the pleadings are just documents that are filed to start a case in federal court. It's just your complaint or answer. It's part of that initial filing.
Thank you.
Motions and stuff. All right, I will see you tomorrow. And I might adjust the reading because apparently I'm being too soft.
But I already did it. And I don't want to do nothing else. I'm done. I'm done.
Oh, wait. This is by myself.
I wish the Cracker Barrel was
I saw your
No. It's mine. Dang, Leanna. Beat me on up. Big ass backpack.
I knew what she was talking about.
I don't follow me on Snapchat.